already in, so I want to welcome you to today's webinar. I am Dana Zivkovich with the Friendly Lawyers Association, and we host these webinars to help you better run your law practice. Our group is centered around helping law firm owners with resources such as networking opportunities, webinars, Zoom happy hours, anything that we can do to keep lawyers happy and finding new ways to collaborate and share good ideas. So today we have Nancy Fallon-Houle, who will be talking all about business law for running your law practice. I know she has a lot of content because I have met with her to go through it a little bit before this webinar. So we're going to start very quickly so she can get through it all. I just have a few housekeeping things that I want to tell everyone. We do have a chat box over to the right where you are encouraged to write in any questions or comments that you have. We find that when people share their own stories that are relevant to what the presenter is talking about, that helps everyone's experience. Also, in this webinar, we will be waiting till the end of the presentation to go over questions, but you can put them in when you think of them, and then we'll go over that list, closer to the top of the hour. We have been approved for 1 hour CLE credit. So what will happen after the webinar, you will receive an email that will ask for you to confirm your attendance and the amount of time that you attended. Once we get that confirmation, we will then send you your certificate. And what else do I have to say? Oh, let me introduce Nancy real quick. Nancy has been a business lawyer for over 30 years. She represents all kinds of small businesses, including small law firms. And I am going to set up a poll here in the next minute, which is going to ask you whether you are a one-person managing, well, I said that wrong. If you are the sole managing lawyer in your firm, or if you have a partner that helps with management, firm management, or if you have 3 or more partners. That'll just help Nancy as she continues her presentation. I'll set that up momentarily, but in the meantime, I'm going to bring Nancy up to the screen.
Let me get my...
Yeah, Nancy, can you set? There we go. Thanks for coming up. And did you want to say a few words first, or did you want me to go ahead and start your slide presentation right away? Good to go?
Go.
Okay. Thanks. And there you go.
Okay. Advance. I'm not. Oh, here we go. Slides. Okay, great. Okay. Hello, everybody. Welcome to our series of business law and tax law for law firms. These 2 presentations today and one in 2 weeks from now are meant to help solo firms and small firms who are, they're just a couple of owners. So my goal here is to help you avoid the pitfalls that I see happen in business formation when things get skipped or fall through the cracks, and to help you do some of the things you can do on your own, and then help you learn which things you shouldn't be doing on your own, and then just items to consider as you think through either starting a firm or changing the entity type or adding partners. The reason we wanted to know up front if you have any partners in your firm is that I've got a few slides on partnership, adding partners, and the governance around having partners in your firm. So if we have all solos on the call, that I've put those to the back and I won't cover them. If we have some partner people who have partners or want to have partners on the call, then I can stay on past 5 o'clock and discuss those slides with anybody who wants to hear them. So why do we care about doing these legal compliance items correctly? If you're going to do a transaction like borrow money from a bank or add or remove a partner, or if you have a client that's a larger corporation, or if you're going to apply for one of these recent SBA loans, the PPP loans or the EIDL or other types of grants at state level. Or if you're going to apply for government certification, which as a minority-owned or a women-owned or a veteran-owned law firm, you can receive referrals for more business than you otherwise would. Or if you're going to sell your law firm, any of these things would require you to have all these documentations recorded properly. Now, I have a note at the bottom too about seeking investor money. This would only apply to some lawyer clients of mine have created software that's a separate business, maybe from the law firm, or some. I know there's a new whole thing now about doing litigation funding. So, of course, if you're going to be seeking investors into your firm or your related entity, then you've got to do all the corporate formalities. And it just goes, it costs time and money and effort to have to go backward and redocument things going backward. And then the challenges, of course, for small law firms to do all these compliance items at the beginning is the cost. So people, of course, try to avoid the cost or do the DIYs. But the issue is that the first two steps to do when you form a law firm or change your entity type need a tax accountant and a lawyer, a corporate lawyer. So the first is the decision on what we should form this law firm as, in a corporation or an LLC, and then other tax issues. And then the other is the name search, name selection, and IP analysis, maybe looking at what you were doing at your old law firm or your in-house counsel job. Those need a lawyer's advice. And then further along, or right after these two decisions, there are other things you can do on your own, which I will teach you how to do those. So allow budget and time for all these extra things. So here's some common legal pitfalls that occur before the formation. You got to consult a tax accountant and a corporate lawyer. Please don't use LegalZoom or Filings Inc. or other legal software to form your company, because they make mistakes that are costly to undo. There are some other legal doc softwares, they're ASPs that hold software of your corporate documents, like Shoebox and Clerky. The documents are not revisable, not editable, and they're terrible. So you've subscribed to and paid for these ASP software systems, Shoebox and Clerky, and then you can't edit what's in there, and you have to pay. You have to copy them to a Word document and edit it. It's just crazy. Don't do it. Costs a fortune. It's tempting to have your accountant form your entity for you. Some accountants think that they are allowed to form legal entities, but it's considered the unauthorized practice of law. So, if you do it yourself, but don't have an accountant do the DIY version. And so the botched entity formation by either accountants or non-corporate lawyers cost sometimes 2 times what I would have charged to get the cleanup done. And then there's the time delay, the momentum stall, and an appearance that isn't that professional. So the name search is one of the most important things to do. And I know it seems crazy because I'm just going to use my own name for my law firm. I'm going to talk about that in a couple of slides later, but it's one of the top mistakes I see made. And on that topic, the word Fallon, my last name, was already being used by another law firm in another state. I couldn't use it. So if you're leaving another firm, or you're leaving an in-house counsel or a corporate law job, you have to look at your non-compete agreement that you had with your former employer. And do you have the legal right to even start this law firm? So it's lawyers under non-competes it's less likely that a lawyer will be under a non-compete. But especially if you were at a corporate counsel job, you might have a non-compete that you don't realize covers what you're thinking of doing. And especially if your law practice might involve developing some software or some other non-traditional legal things. So non-competes are negotiable, even if you've already signed a former one. Keep that in mind. So what you often have to do is look at the non-compete with a lawyer and figure out what's the scope and duration. What are you allowed to do? What can't you do? And is there a non-solicitation, non-poaching clause? And this is typically with your former law firm. You're not allowed to go after the employees from that former law firm, and sometimes the clients. Now, there are some cases out there in the professional services world, doctors, lawyers, financial advisors, where they have been held that a client or patient has the right to choose their professional service provider. So you can't hold lawyers, financial advisors, and maybe even accountants and doctors to non-competes, but those are state by state specific. So just something to check into. And then if you come out of a corporate counsel job, your non-compete agreement might be in your employment agreement, and it might be something you don't even have a physical copy of. It might be in their online intranet in the company. Couple slides on intellectual property. These apply less to a standard law firm practice than they would to a firm developing some technology or clients developing technology. But anyway, it's important to know, do you own this intellectual property that you're starting your firm with? Who owns it? And client list is where it's relevant to our law firms, like who developed it? Were they your clients? Were the firm's clients? The rule of thumb here is if you mess around with money, with taking away money from a former employer, they are more likely to come after you than if you just politely don't actively and aggressively steal revenue from them. And there are actually lawyers who specialize in non-competes for law firms, which is very interesting to chat with one of those if you ever need one. Here's a quick note on IP ownership. So for you as a law firm owner, you own the intellectual property that's created by any of your W-2 employees. So if one of your admins creates a process that's neat, you own it while they work for you as a W-2. But if they are a 1099 contractor, or in some cases a partner or a consultant, they own the work unless your written agreement with them provides otherwise. So keep that one in mind. And also, if you've co-developed any ideas or client lists with former partners, then perhaps they might be co-owned by someone else. Protect your internal IP by doing written non-disclosure agreements. Non-competes are less enforceable, but non-disclosures for sure. Treat as trade secrets all things that should be trade secrets. And of course, we as lawyers have a much higher duty of confidentiality than any other business. But this trade secret issue refers to sharing things across the firm, with inside the firm, or to consultants or people who are helping you work on clients outside the firm. Just quick 3 notes on the types of IP: trademark, copyright, patents. This is not I'm not an IP lawyer, but I see enough of it that I know enough to be dangerous on these. So the trademark law is the one I'll talk about because I do know enough about that. Your law firm name, your tagline, and even a product name, if you're going to create software, is something that has to be trademark searched before you can use it. Even your firm name, your surname may not be available for you to use. But especially if your firm name is not your surname, like mine is Velocity Law, and others have other names. By the way, in some states, you have to use a name of one of the lawyers in the firm name. And in other states, you can use a branded name, like Lexology or whatever. Copyright is what we apply to our, I forgot to put the copyright. Oh, my copyright symbol's on the front page of my my PowerPoint here. So anything that you write, your website content, any art or video, music, images, any software you write, any manuals or books, those are all copyrightable, not trademarkable. And patents don't usually apply to lawyers and the work that they do, but there are some client lawyers of mine who have created software for various types of law practices, so they can file a patent in those in some cases. So now down to the name search and selection. Your firm name, your tagline, your logo, and any product names have to be trademark searched and cleared before you can use them. You can search for free on uspto.gov, trademarks test. The link is there. It'll also be in the materials that we are sending you. I have also included a whole name search and selection checklist that teaches you how to search names on your own and how to think of a cool name if you're not using your personal name. If you're using your personal name, still have to search it, make sure there's no law firm using that same name. The common law rule of thumb is the winner is the first person to use the name in the category, the trademark category. Our category for law is Class 035. Even if it's not trademarked, if the person has used it before you, they are the winner of that name. We're all doing business on the internet all over the country, so you do have to search outside of your own home state. You cannot use a similar name or a likely sounding name or something that causes likelihood of name confusion. Really challenging when you're using your own name. I had a client that wanted to name a trading firm Dune Crest, and there was a trademarked name Dune Crest. So it sounds alike. It sounds like enough that the trademark lawyer told him to not use the name. So and then if you think that the word order or moving the words around makes it okay, know about this case in Texas in 2016. The Houston College of Law was required to change its name by a federal trademark court after University of Houston Law Center sued the College of Law. So Houston College of Law, University of Houston Law Center, there are only two overlapping words, different order, but the later user lost the case. So name searches are required at multiple levels. So that was the trademark searching I was referring to. Of course, search Google, search your own state trademark, search your state corporate and LLC database, and then search. You can search common law uses by Googling, by doing DBAs, by the state business taxpayer registration rolls, and domain names. If the domain name is available, it doesn't mean you can have it. You can have the name. The name has to be also available to be trademarkable. There are surveillance services that you use to help search the names. You can pay Markify or Government Liaison Inc. or Thompson & Thompson's to do a name search for you in all 50 states at once, and the trademark and all these databases that I'm mentioning. It costs between, I think Markify is like $600 or $800. Thompson & Thompson's charges $1,600. So there's all levels of search tools you can buy a third-party searcher to use. And even I don't trust my own brain to think of all the possible permutations of names. So I advise my clients to hire these search tools. We might have some trademark lawyers on the call here who are going, yay, glad somebody's mentioning this. and we can talk later about that. Beware of the marketing folks you hire to help you design a logo and a brand. They don't always search the trademark names. So now you know to do it as well. And allow lots of time and mental energy to do this name search, because often the first name you choose is not available. I searched for my law firm when I changed it from my own personal name to Velocity Law. I searched 44 names and none of them were available. Bummer. USPTO.gov, and there's a checklist with the materials that'll teach you in great detail how to search your own names. Changing the name later is costly and embarrassing, and you lose your brand momentum. You have to change your bank account number, change your credit cards, any kind of contracts you're involved in. So it's no small task. Now, onto the formation of the entity for those who haven't formed yet or might be thinking of changing to an entity. Here are the classic mistakes I see. Forming an LLC instead of a corp, or forming a corp instead of an LLC. This entity type decision is almost purely a tax decision. There are a few corporate law and business issues that I'll talk about later. But in 2 weeks, Scott Singer is going to cover all of the tax decisions. If you change your entity type from a sole prop to a corp, or from a corp to an LLC, or an LLC to sole prop, it's a taxable transaction, because the IRS deems that you have liquidated your assets of your law firm and donated or contributed them to the new firm. Now, some tax accountants are able to figure out a way to avoid that tax on the entity change. My point is, make sure you get it right at the start, because there are ongoing consequences. So an LLC can be formed as either a member managed or a manager managed. Unfortunately, the default on at least the Illinois Secretary of State website is member managed, which you do not want. You want manager managed LLC, because if you ever add other partners in the future, you want to be able to designate only those you want as the managers to be managers. If you had formed a member managed LLC, every person who becomes an owner or a partner is a managing member, is on the management team. And that could get, out of control, especially if you're adding, younger partners with smaller percents of ownership, 5 or 10%. You don't want them on the management team. But if you've got a member managed LLC, they are automatically on the management team. Use your home state as your state of formation. Don't use Delaware. Nevada and Wyoming were set up to allow people to obscure who the owners are. But heck, with law firms, we want people to see who we are. We want them to be able to check due diligence on us. So form in your home state. Hopefully it's visible, it's transparent, and don't use Delaware either. That's for tech companies or startup companies. If you're doing your own formation, the business purpose has to describe a law practice or practice profession of law. In some states like Illinois, you can either form as a PC, a professional corporation, or an LLC, or as a regular corp. If you form as a PC, you have to state you just stick in the word law as your practice purpose. But if you use a corp, S corp, a regular S corp, or a LLC, you have to state what is the business purpose of your business, and it has to use the word law or law practice as part of the description. There are some attachments that I attach to my articles of formation of LLC and corporation that impose restrictions on transfer. They remove the effect of some weird cases in Illinois. I don't know if other states have such things, but I always attach this attachment to the articles, which you can't do on LegalZoom, for example. You should be your own registered agent. Don't pay somebody to be a registered agent. unless you are trying to obscure your name, like temporarily, if you're at a firm and you want to leave and you're starting your own, then by all means pay a registered agent. But if you're not trying to obscure your name, don't waste the money, and it's better to have your name shown. When clients conduct due diligence on your entity, they're going to want to see your name in all the slots. Don't forget to qualify your firm in other states. If you've got offices in more than one state or clients in another state, you might have to qualify your firm in other states. Now, not to freak us all out, clients in another state is really not necessarily a, go qualify in that state. But if you have a partner sitting in an office in another state, qualify in that state. If you have an office in another state, qualify in that state. And qualify means take your current state's articles of incorporation or LLC formation and file it in that other state. And it's like another incorporation, your entity's just getting cleared in that state. File your local business license in your current state and in any other where you have an office. File the IRS 2553 to elect S Corp status if you're going to be an S Corp or an LLC taxed as S Corp. And here's a tricky one, maybe. So we all have our license to practice law in our home state. Great. But when you form a corporation or LLC, that entity also has to be licensed to practice in the state. It's a really simple filing. It's a $35 or $40 fee in Illinois and a 2-page form. It's the professional licensing arm wants to have their say to know who's out there. Almost every state has a similar thing. In Illinois, it's a Supreme Court filing. Now to this perennial question that everybody wants to know. Dana said she receives this question more often than anything else combined, I think. Now, as I mentioned before, the entity selection, Corp versus LLC, is almost purely a tax decision. So Scott Singer will cover those in 2 weeks. But I'm just going to say a few things in general about them and on the corporate law side. Within the entity type, there's also a tax type decision. So an LLC can be taxed as 3 different types of entities. It can be taxed as disregarded, taxed as, which is sole prop. It can be taxed as S Corp, taxed as C Corp, or taxed as partnership. The tax law in 2017 made it even more important to see a tax advisor before you pick your entity type. And now Scott and others have told me that the 2020 election may even change that further. So if you, as I mentioned before, if you change entity type after you're operating or after the first tax year, it could be a taxable transaction. One, on the corporate law side, something to consider is whether your firm will have a 401k plan and whether the partners will contribute to that 401k plan, and then how long you want the partners to be able to contribute. So Scott will cover some things next week, but in short, if you have partners who have retired and they still want to contribute to the 401k plan, they can only do that if you're a corporation. They cannot do it if you're an LLC, taxed as partnership. So one slide on when you should be an LLC and another slide on when you should be a corp. And these are only the corporate law issues and business, not the tax law issues. Although I'm going to talk a little bit, touch the surface on some tax things. So if your firm is going to own real estate, form it as an LLC, not as a corporation. That's a settled area of law. If your partners will never want to take W-2 payroll checks, like they might have already they already have all the Social Security benefits and enough retirement savings that they don't care about doing W-2 paychecks that allow you to contribute to Medicare and Social Security tax. You lose some some money on doing W-2 payroll checks. So some partners don't want W-2 payroll checks. If you're an LLC, you cannot do W-2 payroll checks. So if you want W-2 payroll, be a corporation. If the firm wants two classes of partners that can't simply be addressed by voting rights by percentage of ownership being small versus large, if the firm truly wants two classes of owners, like a income partner and equity partner, or profits interest versus equity ownership interests, then you have to be an LLC, not an S corp. An S corp is not allowed to have two classes of ownership. An LLC is. If any owners are not U.S. citizens, you have to be either an LLC or a C corp, which is a bad tax decision. So in short, if any owner is a not U.S. citizen, you want to be an LLC. Because S corps cannot have non-U.S. citizen owners. And again, if there's no 401k contributions needed, then you can be an LLC. So you want to be a corp. This is, most CPAs advise forming as a corporation for law firms, which is kind of surprising to some people, because the prior rule of thinking was, if you're any kind of a service company, be an LLC, avoid paying your payroll tax. But Scott will tell you more in 2 weeks about why, but you should either be a corporation or an LLC taxed as a corporation in most cases. So you got to get this advice out of your own tax advisor. Here is a shocking tip. If you form as an LLC as one partner, and then you later add other partners, meaning you're changing your tax status from taxed as sole prop to taxed as partnership, you have to get a new FEIN. That means new bank account, new QuickBooks file, new credit cards. It is a royal pain. I've had people do it, and it's not worth doing. So if you think you might ever add another partner, either form it as a two-partner LLC now, which you can't do with only one partner, or form it as a corporation. A corp can have any number of owners at any time. This is a tax law point, but if the partners want to control how much self-employment tax they're going to pay, you might have heard of the 60-40 rule, where in a corporation, 60% should be W-2 salary and 40% should be distributions on K-1s, where you can get out of paying self-employment tax on the distributions, or payroll tax on the distributions. So this is sort of getting into the weeds on tax. I'm not going to go through that, but it's one of the decision factors. If you're making another business, if you're in another business and you already are paying, or you're already, employed by somewhere else and you're already paying your maximum self-employment tax, you might want to be an LLC, not a corporation, or Scott will tell you how to work this. Talked about the retired partners already. Oh, if your firm will be selling software or other goods, you should be a corporation instead of an LLC. And again, if any law partners live outside the U.S. State of formation, we did that already. And then why not be a sole proprietorship? So you have personal liability in a sole prop. Beyond your client professional liability, which is covered by your malpractice insurance, there's also liability for debt, your lease, where your office is to vendors, slip and fall cases at your office. Any of these things can trigger personal liability to you if you don't have the protective entity of a corp or LLC around you. So I know a lot of lawyers think if they've got professional liability insurance and some slip and fall insurance, they're probably okay. But as a corporate lawyer, I disagree with that. I think everyone should form their business, including a law firm, into a corporation or LLC. Your client's perception of you and other professionals will be more professional if you're not a sole prop but are an entity. It says that you're serious about your law firm enough to form it, to spend the money to form it into a business. On the personal name use, if you're allowed to use a branded name, I'm a fan of that, but it's your choice. My law firm was named Nancy Fallon-Houle PC for 15 years. And I feel like it just says I'm small. It's just me. I don't have any associates. I'm little. And if you want to give a bigger firm impression, then name it something that isn't you, or use your name and associates. Due diligence on your firm by your clients and referral partners is easier to do if you're formed as an entity, because your business name is right there on the Secretary of State website. Property insurance is easier to get if you are a corp or LLC versus if you're a sole prop. And larger company clients, if any of us is so lucky to have some of those, they typically require that you form a corp or LLC. They won't hire you as a sole prop because you could be accidentally deemed to be their employee, and they don't want that. In a corp or LLC, it's easier to separate the financial and tax matters because from if you are a sole prop, your income and loss goes on a Schedule C, which is on your personal tax return. And of course, we should always do a separate checking account for the business, but it's just easier if you have a separate 1120S or 1065 tax return for the entity. If you are a sole prop and you're for some reason asked for your business tax return in due diligence, landlord or some big clients maybe, you'd have to show them your entire personal 1040 because the Schedule C is on the 1040. Whereas if you're a corp or partnership or LLC, taxes partnership, you have a separate business tax return, the 1120 for the corp and the 1065 for the LLC taxes partnership. You just give them that tax return. Did this already in the front slide about why you would have to, why you care, same as why you care about doing the legal compliance is the same reason of why you would want to be an entity and not a sole prop. If you're going to add other people, apply for a loan. Side note, on this recent SBA set of loans, the Paycheck Protection, corporations were treated with more respect by the SBA than were LLCs, especially single member LLCs. The government doesn't really understand LLCs very well, so they put the people who could get PPP first were corps. And then the second round was those who were LLCs, especially single member LLCs. So I feel like LLCs were treated with disrespect in that. And, maybe that's a good reason to be a corporation. Hopefully we'll never have another pandemic again where we have to get federal money. If you're going to add, remove partners or issue some equity, to your younger associates, or if you're selling the firm, you would have had to have been not a sole proprietorship, but an entity. Okay, here are the filings that you would have to file. Actually, Dana, did you want to ask me any questions before I start into the filing part, or keep going?
Well, if we're going to take a break for questions, I did have a couple of them come up. So yeah, I'll take advantage of that opportunity. Okay, here I am. So one question that came up, and I apologize if you did answer this and I didn't catch it because I was also kind of monitoring the dashboard. But one question that came up was, why no PLLC?
Oh yeah, so a PLLC, it's you mean an LLP? PLLC. Oh, why no LLCs to be used? Is that what they're asking?
Well, the question said, why no PLLC? Maybe like you're saying, LLP?
Yeah, I didn't address LLPs because they're usually bigger law firms that do those. I figured it wasn't part of our thing, but an LLP is like an LLC. It's treated like a partnership, and very similar corporate law things apply and tax law things apply. So why no? Because I just didn't put it in on my slide.
Well, when the difference between an LLC and an LLP, let's start with that, because I don't know. I have seen some firms called LLPs, but to a lesser degree. Is there an obvious difference, or are they essentially the same?
I do not know all the nuances of all the differences, but an LLP is a limited liability partnership, and an LLC is an entity taxed as a partnership. So what I understand, so the LLP is governed by partnership law, and LLC is governed by partnership laws for LLCs, if that sounds weird. Okay. So there are a few nuances that are tax related and basis and, things that Scott will talk about where LLPs differ. And I do not know all of those, but I know that big law firms use LLPs and smaller law firms use LLCs. And actually big law firms make the partners form their own LLC or corp or LP, or I'm sorry, LLC or corp, and make the individual lawyer's entity be an owner of the law firm's partnership, LLP partnership. So I bet that answer your whole question. Well,
the viewer also added a couple chat comments to clarify. She says that maybe it's unique to North Carolina because she thinks they have to be a professional LLC, which would be the acronym PLLC.
Oh, yeah. Okay, I know what you're talking about now. It's what I mentioned earlier in Illinois. You can be either a PC, professional corporation, or a regular S corporation. And we don't have the PLLC in Illinois, but obviously you do in North Carolina. And yes, there are states where you're a professional services firm has to form under that type of entity. So It sounds like in North Carolina, you have that.
Yeah. And actually, I'm glad that this came up because it gives us just a 3-second clarification that all the materials that you are covering are basically Illinois practices, procedures, and laws. Can I confirm that just so that we don't have any confusion that we're talking on a national level?
I'm an Illinois lawyer. I have clients in other states. I do these talks and considering that there might be other states' laws. So for example, when I talked about the non-compete, I said, and this is what Illinois, the default in Illinois is that the employer owns the intellectual property, but it could be different in other states. So, and I've tried to say where it could be different in other states, but my background is in Illinois and Delaware. I know Delaware law as well, so.
Okay. Another question that came up was, can S Corps have legal resident aliens as shareholders?
They can have resident aliens as shareholders, yes. They have to be citizens or resident aliens.
Okay. Well, that gets us all caught up on questions. So I'll turn the slides back over to you.
Okay. Do you know where we were on them?
Right there.
Fantastic. Okay, great. So I'm just going to buzz through really quick. These are the physical filings you have to make. And if you're going to do it on your own, use this as a checklist. So the articles of formation, you file a federal tax ID application on the SS4. It can be done online. That establishes your payroll, your taxpayer ID for tax returns, income tax returns, and for payroll tax, if you'll be having payroll tax. If you want to be an S corporation or an LLC taxed as S corp, file the IRS 2553. It can sadly only be done in paper. It's my nemesis. one of the only things you can't file online, and to make it worse, you can't use a DocuSign form that on an IRS 2553. So you have to mail it. I send them by FedEx. File your state's Department of Revenue business taxpayer registration. So if you think you're done at the federal level, nope, there's one more. Do it at your state level as well. And that gives you a state tax ID for income tax, payroll tax, sales or use tax, and other specialty taxes. And then in Illinois, it's called a Reg 1. We also have a Reg 3D and 3C to make changes. Don't forget your local business license, either your city or village. It's usually a half-page form, $35. They just want to know that you're out there. There might be a county license if your office is in an unincorporated area. And then we mentioned the Supreme Court or other professional licensing that is typically required of the entity. And then don't forget to change your ARDC, your attorney registration record, to show that you are now under under a law firm. If you're using a nickname for your firm or a shortened name, you would have to file an assumed name filing with the state. And sole props can file assumed names. File a trademark filing if you're using a branded name. You might even want to do it for your own name, but especially if you're doing a logo or a tagline, consider filing a federal and or state trademark filing. And then qualifications in other states, we talked about that already. And then certifications, talked about that. Let's talk now about the corporate formalities. And the word corporate is used to refer to both corporations and LLCs in this sense. So the formalities are that you've formed the entity, that you've documented your ownership. Oh, let me just go back and say, you want to do these corporate formalities, aside from the fact that it'll help you in a transaction, that you don't want to get your corporate veil pierced if there's ever any litigation, that your personal assets might be at risk. So you have to operate it like it's an entity, not like it's a sole prop. Otherwise, your corporate veil might get pierced. And corporate means LLC or corporate. So, and these corporate formalities apply even if you are a sole owner of your own corporation or LLC. So form the entity, document who the owners are. Your bank wants to see something that shows you're the sole owner or who are the owners before they open the bank account. Make sure you make your capital contributions. If you're capitalizing it with $1,000, write that check to the company or use that money to pay for something for the company, and that's your capital contribution. Now, this is less of an issue when it's just you, but if you have more than one person, you want those capital contributions to be documented because they prove the percent of ownership. So if you got two partners and you're, 60-40, make sure one person wrote a check for 400 and one for 600 to the business checking account. The corporate resolutions establish the corporate authority to operate, to issue the shares or LLC interests, to operate the company, to elect officers or managing members, to give authority to signers, bank signers or contract signers, spending limits, voting rights, allow you to purchase or lease property. So there's this set of documents called the corporate resolutions that give that authority of the company to act. In an LLC, you can either do corporate resolutions, LLC resolutions, or you can put all this stuff in the LLC operating agreement. Keep your corporate records straight. Sign the documents, anything, sign in your law firm name, not in your personal name. Even if some people are going to give you a DocuSign with your personal name, like your IT firm is going to just put your name on it, you need the two lines, the signature line that has the company name by you as officer. Do all your tax return filings, do your corporate maintenance, file your annual report with the Secretary of State. It's not a tax return, it's a corporate or LLC annual report that pays a tax every year. Basically, it's usually a couple $100 for the privilege of owning shares in your state or owning LLC interests in your state. Maintain insurance. Maintain separate actions between the corporation and your personal. So don't mix finances. Your accountants will be telling you this, and so will Scott in 2 weeks. If you have two businesses, like the real estate LLC that owns your offices, or if you've got this software thing you're doing on the side, don't mix finances between those two entities. Write yourself, if you need money in one, write yourself a payroll check or a distribution check, personal, and then invest it back into that other entity. If you're mixing things between two entities, you have a risk of getting the corporate veil pierced. Keep all your corporate documents at hand for due diligence responses and operate it like a business, not like a hobby. Here are some mistakes I see that people make in forming their own corporations. Some of these apply to just to one own corp, and some apply to multiple owner corps. So the shares are not actually issued, which those corporate resolutions do. The ownership percent wasn't decided. I push my law firm clients, if we got 2 or 3 people, you got to figure out the percent of ownership at the beginning, because when the first tax return comes around or the first big bill you are splitting the cost of, there needs to be a decision made of who owns what percent, and therefore who shares what percent of the expenses. You have to make the capital contributions, as I said earlier. Do a stock ledger or share ledger to document the ownership. I'm going to skip these. These are like mistakes in par value that happen, that if somebody's going to be a corporation, you can either read the slide later, or you can talk with me. A lot of folks have confusion between owners, board members, and officers. So the owners own the company. The board members run the company. They might be the same people. They will be the same people in your solo law firm or even a 2-person law firm. But you are acting in 2 capacities, as an owner and a board member, when you're taking action or signing. The S Corp election we talked about already. We did these things already. The corporate resolutions should be done whenever there is a material corporate action. I set up my clients' corporate resolutions that allow you to use these original organizing and operating resolutions as your operating document for the future. No changes needed unless some material thing has changed, like you're adding another partner, or you're selling the firm, or you're renting a big office space. You can do a shareholder or LLC agreement. You don't need one for a sole member. I wouldn't waste the money on it. But if you have 2 people, you should do something in writing, even if it's a set of emails between you guys. Of course, a full shareholder agreement or LLC agreement is better, but not everyone can afford that. So just make sure you define what the profit and loss sharing is and how it's allocated. Your profit and loss sharing in an LLC might be different than your ownership sharing. You have to define profit. It could be net revenue. It could be gross revenue, or it's not gross revenue, but it could be gross revenue minus something, net revenue. It could be net income. It could be net income before taxes. It could be EBITDA. So there's so many definitions of profit. It's really important to write down how you're defining profit in your documents. Establish the voting rights. If you've got a 60-40 firm ownership, or a 51-49, or a 50-50, state what percent of vote is required to pass an issue, especially if you've got 50-50. The rule is 100% then. You don't want one partner being able to take action without the other. Make sure you've got an indemnification provision in your corporate resolutions that allows your officers, directors, and partners to be indemnified if, in other words, funded if a lawsuit hits them and it's more than the value of the insured amount. So did we learn how many people are solos here, Dana?
Yeah, based on the poll that we put out, it was 100%.
Okay, I'm going to skip this slide then. But I will just say, if you're ever going to add partners, you have to sort of do this thinking again. Put the capital contribution in. What percent does each person own? How do you allocate P&L? And how do you distribute P&L? So we'll skip this since we have all solo people. These are somewhat applicable to partner law firms where there's more than one. But know that if you are a partner in an LLC or an LP, or even in a corp actually, you are personally liable for all the debt that is in the company, but you're not liable for any debt or liability that's outside the company. And that's the only thing I'm going to, and dissolution. If you're ever going to dissolve your firm, this is like a business issue. As lawyers, we have to do lots of things with our client files. So I'm going to skip, these are really partner discussions, including, file your annual report with the state every year. If you don't file your corporate or LLC annual report, the state will dissolve your entity. And you don't have an entity. So now you're back to being a sole proprietorship, maybe. This is a little table I created that helps people clarify owners versus management directors or managing members versus officers. And this will be in the materials. It's in the slide deck. So in short, the owners own the company, the management board runs the company, and the officers implement the management board's strategic vision. Each of these are elected by the people below them. Owners elect the management board or the board of directors, and the directors or managing members elect the officers. Since we only have sole owners here, I'm going to skip the slides on issuing interests, except to say that when you form your corp or LLC, issue yourself your shares. I would just do it in a stock ledger, in an Excel sheet or a Word document showing that the shares were issued to you on that date. Your accountant will need that to do your tax return, because they need to know, who owns what percent of the company and proof that you're the sole owner. So I'm going to skip the rest of this on partner kind of things. And these are adding law firm partners. So I will just say that if you are thinking of ever adding a partner, first of all, if you operate a law practice or any business as a sole proprietorship without an entity around you, and you're in business with another person, you are a de facto limited partnership, or I'm sorry, de facto general partnership. Yikes. A general partnership has personal liability to all of the owners of the business. So if you are treading into starting to do business with another lawyer, form it quick into an LLC or a corporation. All law firm owners must hold a license to practice law in that state, but I know other states have differing rules. Don't make just anyone a partner or an owner of your company. You can fire an officer. You can vote out a managing member or a director. You can fire an employee, but you can't fire an owner. You have to buy out the owner at the current market value of the company when you get rid of them. So it's really important to make this decision only making your most trusted partners, people you know as partners. So if you're doing a one-shot deal, do it as a joint venture or something. And I'm going to go ahead, and I'm going to skip the.
I'm popping in because we are at the top of the hour, and I just wanted to take a few minutes to allow a transition. I know Nancy is willing to stay on and finish her presentation, but I also know that sometimes people have other obligations, and so I wanted to be sure to get a couple of my pointers in before you have to sign off. And if you do have to sign off, in the next 30 seconds when I'm done, that would be the right time to do it. So before anybody signs off, I just wanted to let you know that I did get a couple notes from people saying they could not find where the handout was on this platform. And to make it very simple, I will simply email everyone directly a copy of Nancy's slides shortly, right after this presentation. So you don't have to worry about that. Also, I would be remiss if I did not mention that this webinar was sponsored by Messenia Advisors. So I would like to express my appreciation for their willingness to sponsor this webinar so we could bring all of this to you, all of this information. And another little reminder is that we have organized this for the first time as a two-part series. So the two parts work together. Nancy has covered all of these business law issues, and Scott Singer will be covering tax law for these same sorts of issues for law firm managing owners. His presentation is in 2 weeks in the afternoon. I don't believe we have confirmed the time, so just be on the lookout for the promotion that we'll start doing it, but I know it will be in the afternoon. And Scott is a CPA out of Naperville. Little information for you about him, and I hope you guys will join us for that second part. And yeah, I think that's all I really wanted to say. So I'll let Nancy continue, but thank you for joining us for this last hour. And if you have to go, feel free to sign off at this point. Otherwise, I will get out of your way, Nancy.
Okay, great. We're going to go on with worker classification next. So that's slide 30. Okay, so we're done with the law firm partner thing. So we all have this question: if we hire people to work for us, are they W-2 or are they 1099 contractors? So it's a tough question, and the IRS is kind of after people on this. I wonder what's going to happen now after the COVID thing, where a lot of people laid off their employees and now they're hiring back a little bit as 1099s. It's going to be a crazy. But anyway, the mistake people make is most people who categorize people as 1099 consultants, they really should be W-2 employees. So at the outset, anybody who's a full-time worker, they should be a W-2 employee. Even part-time workers probably need to be W-2 employees if you are their sole employer. For example, in Illinois, they have a rule that if you got a part-time person and they work only 10 hours a week, they can be deemed an employee if you are their sole employer. So the IRS and the states presume employee status even if they're part-time. And just note, it's kind of a hot issue. The IRS and some states are actually retroactively classifying people who were shown as independent contractors, 1099ers, to be, W-2 employees, and you could be retroactively liable for all that payroll tax. They're after certain industries that are not law right now, so it's not like they're breathing down our necks, but just try to do it right. And then, payroll tax is expensive, so figure it in the cost of your rate you're charging your clients. It's cost you 15% more on what you're paying your employees to treat them as a W-2 employee, but budget that into your pricing. So there are other factors if they're not a full-time person. So here are some factors the IRS considers. Do they do work for anyone besides you? Like, do they have other clients besides you? If you've got a legal secretary who works for 2 or 3 firms or 2 firms, then maybe she's an independent contractor, or he, and not a W-2, who has control over the worker, their hours, their work location, although this work location is kind of out the window now. And so is the equipment used. Rule of thumb. It used to be that if they worked in your office with your laptop or your computer, that's a W-2 employee. And if they work for their own home using their technology, then they are a 1099. They could be a 1099 contractor. It'll be interesting to see what happens after the COVID work at home blitz. And there are other factors as well. Note that insurance that you buy for your workers, to cover your workers, will differ if they are employees versus contractors. And you might not have coverage for somebody that's a contractor, which you would have if they were a W-2 employee. And then we talked about the IP ownership. If they're an employee, you own their work. If they're a contractor, you don't own their work. In Illinois, and I'm sure in other states, just be aware that there are these short filing deadlines when you hire somebody as an employee. There's a reporting requirement in Illinois and other states. You got to report who your employees are. If you hire someone that turns out that they're not going to work out and you're kind of getting a bad feeling, get rid of them before the 30th working day. That's the Illinois rule. I believe other states are similar, because if you, you don't want to fire them, they might work out, whatever. If you wait for 30 days, you're stuck with a potential unemployment claim by them when you do fire them. If you fire them within 30 days, they can't claim unemployment. New hire reporting rules, just talked about that. Oh, this is a child support deadbeat search tool that our states are using. You have to report all new hires within 20 days of hiring the person. And then there are federal and state employment laws, which I'm not an employment lawyer, but I'm just going to tell you, you can look at this slide later. There are rules on overtime pay. There are minimum wage rules. You can't hire an intern and not pay them unless they are at a university or law school program where they're getting credit for the work they're doing at your office. So you can't just have an intern and not pay them, or pay them below minimum wage. And then the OSHA stuff, which that's all bets are off on the COVID too. Harassment, discrimination. There's Illinois and other states have new sexual harassment training rules that you, even if you're the sole owner of your firm, you have to take a sexual harassment training class in Illinois by 12/31. If your other states, not sure what those are. Some of the federal and state rules won't apply to us as solo owners, but a few do. If you're getting rid of somebody, write up the cause, the for cause thing, so you can, meet that burden. Unemployment claims, increase your rates. I think we're all going to be paying higher unemployment percents after this crazy economy. We all know about engagement letters, but I have two things I'd like to say about current day, modern day things that I'm seeing happening. One is that more than ever, and I wonder if people are seeing this, that other law firms are hiring law firms to just do limited scope work for a specific area of expertise or a project. So there's a lot of this farming out of work going on. So the hiring law firm and the hiree law firm, the contractor, have to both be really careful about limiting the scope of their engagement, which limits the scope of your liability. Like I'm guessing a lot of you, are seeing tons of clients doing DIY work. I think Dana has seen it in estate planning, and I've seen it in corporate law using LegalZoom and these other things. So I've now taken to disclaiming my responsibility for work done on these law sites, because the stuff is garbage. I've heard the Susie Orman things are garbage for estate planning as well. And can you imagine that intertwining of what the legal website did, and then now you're parlaying on top of it? Yikes, what a mess. So get in your engagement letter that you're not responsible for what was done on that website unless you redo it. I'm a big fan of writing everything in plain English. There was some case an ARDC case in Illinois where a lawyer got in trouble for charging time for an assistant whose rate had not been stated in the engagement letter. So I state a rate of my assistant, even though I never use her for anything, but I now state the rate of myself in my assistant.
Yeah, I do as well. Just chiming in here, I state the rates for everybody.
You must have read that same case.
Believe it or not, I didn't realize that was an issue, and I didn't know about that case, but I just had included it. It seemed kind of like common sense for me. If I was going to be billing them, then the client should know what the rate is.
Yeah, and you never know if you're going to be adding somebody. I state my rate, an associate rate, and a legal assistant rate.
I do as well.
I don't have any associates right now, but just in case. So this is just a point for business clients. But Dana, I wonder if this also applies to like trust clients. The question is, who's your client when you're dealing with an entity? So if it's a corporation or LLC, if your client's an entity, the entity is your client, not the owners. And this is really hard to parse out sometimes because one of the owners has hired you, or a couple of them.
The comment that I can make on that is that you could have a whole CLE on who is your client. It's a supremely important. I think we could all agree. I do a lot more probate than I do estate planning. And in that context, it is also sometimes confusing. A lot of people, I can tell you, think that the estate has an attorney when actually people have attorneys. And so it depends what role that person is in the estate. But I completely agree that knowing who your client is and relaying that information to the client could solve a lot of problems.
Mm-hmm. So I think I'll just skip on the issue of communication with the client. I'm a big fan of copying all the owners of a corporate client. And my clients are small business clients, so I'm copying 2 or 3 people, not 100 people. You want to copy everybody so none of the owners can say, she was favoring one guy and gave him the stuff. Maybe that's the same with the trust and estate work as well. Yeah, in my case, I often have children. So children are assisting their elderly parents, but really the elderly parent is the client, but the child is the point of contact. So yeah, it can get tricky. So on that point, if you have a dispute in your trust situation, or in my case, in my business law clients, now you've got a real need to make clear who your client is. Yeah. In a business split up, they're suing each other. So now who's your client? So you can withdraw from representing the company and represent one client, or you can represent the company, but you got to be so careful about what you say to the individual owners of the company. And it's especially tricky when you're trying to give legal advice right as the split up is happening. I've seen this, and it's, whoa, you got to be careful. Yeah, it sounds like it could be a slippery slope real quickly. Yeah, and if the entity was formed by the client on their own and they didn't do operating documents, which is pretty common, there's no roadmap to tell you what voting rights are, or who are the owners even sometimes. So now I have a couple slides on business. This is just technology stuff, really. So the legal part is pretty much done, except I've got partnership slides and website things, but I'm going to gloss over this because it's so late, and I knew I was going to go over time here. But Google Docs, the free version, is not secure enough to use for a law practice. And cybersecurity is absolutely critical. If you get your law firm hacked, it will kill your firm. So it's hard for us solos to spend the money we need to spend on technology and, you know, protection. Do a cybersecurity audit. We have to do it though, because, you know, we have social security numbers and PII all over the place. Oh, if your website's under construction, just put at least something up so you're able to have due diligence or referrals from people. They need at least a website that show you. And you might need an IT firm to do your workstations, and if you have a server or your cloud stuff, you might need a website firm to do your website and a search engine optimization firm. There's lots of different tech people that you need, and they are rarely ever able to be handled by the same person. One of my pet peeves of somebody that I'm going to make a referral, I'm going to give Dana your name to somebody for estate planning, and the person I'm making the referral of doesn't have an emailable brochure or at least something written up. I have to write up a story about the person I'm referring. That is really crazy, right? So get something written up so you can make referrals easy. This probably goes without saying now, but if anyone is still using an AOL, Hotmail, or Yahoo address for your law firm, you look like an old school and cheap fool. So don't do it. Gmail is more sophisticated, but it's even better if you can buy your domain name and use that. I personally love Office 365 for email exchange and Outlook. Data rooms probably only apply to those of us who do transactional work or litigation, but there's something called a data room where you can upload your client docs to be viewed specifically for that transaction or that litigation matter. Not to be confused with the portal that your accountant has you send documents up to. But the data room is a temporary thing that you put stuff up into and take it out. They cost money, but if you're doing a big document transfer to multiple parties, you probably want to pay for a data room.
Or sometimes that could even be used within a legal case management software subscription.
Yes, and you can share those with other people in the case management, right?
Yes, you can share it internally inside your office or externally to any contact which you control, whether they have, access to a particular document or documents.
Fantastic. And don't forget to back up your data. Of course, we know this already. So on websites, you have to own the IP that's on your website, or you have to have permission to use it. If you're saying something about your law firm, it's got to be true. You can't say you handle a kind of law that you don't handle. If you're linking or cross-referring on your website to another website, check that and make sure that there's no implication of a relationship that isn't there, unless there is one. And check it and make sure what they're saying is still true. Like, are you referring to something that's, fraudulent or whatever? I think we all know now not to collect credit card numbers on your website. There's so much really great software out there, LawPay, so we'll skip that. State terms of use and conditions on your website, if, whatever rules there are for entering it, and a privacy policy. Email blasts are spam and they're illegal under the Can-Spam Act. So don't send people emails unless they've given you permission. And some folks think that giving somebody a business card means I give you permission to spam me. That is not true. You have to ask permission. And if you are sending one of your wonderful, beautiful monthly newsletters out, an email blast, you have to have an unsubscribe link somewhere in the email. Otherwise, it's breaching the Can-Spam Act. And the subject lines have to be indicative of the content. You can't say, you know, free coupon for, you know, for free legal work, and then there's nothing in it about a free coupon for free legal work. So I can stop here or go on for whoever wants to stay on some contract issues. Let me see.
How many slides? Well, let me just ask you real quick. How many slides do you have?
Contracts. That's pretty much
just a couple more slides. Okay.
Yeah, 2 more of the contracts. Yeah. So do people want to? Should we ask questions on the prior stuff?
Well, I haven't had any questions come in through the chat, but I think people, knowing that you have a couple more slides, there's still a handful of people on. So if you want to go through, just go through it, and if a question comes in, I'll bring it up.
Sure. I have 2 more slides that I'm going to cover, and I had more if we had time, but we knew we weren't going to have time. So we tend to, as lawyers, tend to forget that we are entering contracts with our vendors or our large corporate clients. So there's some gotchas in some of those contracts. First of all, remember, an email is a writing, so a writing is a contract. Digital signatures are legal. We all know that. Except the IRS won't accept a DocuSign signature on an IRS form if it's stamped with the date and timestamp. So all these things go without saying. Retroactively papering oral agreements is the most expensive way to do it. But we know this as lawyers, but read every word of even your IT firm's contract. There are some weird things in those that you want to make sure you're not agreeing to or changing them. If you have a big client, they'll be giving you their version of their engagement, their consulting agreement. So watch out for the reps and warranties and the indemnifications. The reps and warranties say, I represent this to be true, and I warrant that this is true or will happen. And if I don't, if I'm stating something wrong, I'm indemnifying the other party for their losses. So you probably only see this in a big corporate client, but you might see, if you're representing corporate clients, you'll see it. Just read that stuff. It's key. And understand how a contract can be breached. And then, of course, don't forget to sign the contract. But how many of us have seen clients who don't sign the stuff we prepare for them? And it's not valid if it's not signed. This is for doing, let's see here. You know what? And in the very bottom there. So if the contract is signable, you may want it to be assignable and you may not want it to be. So read that boilerplate and make sure it applies to your situation. Okay, that is, this is all change in ownership. Oh, a quick note, if you ever do add partners, you have fiduciary duty obligation to all of them. And due diligence, watch out, us small firm people. Bad guys prey on us. Small firms, they think that we're too stupid to do due diligence on them, and we're not. So, and don't be. So that is. And if you're going to sell your law firm, there's planning steps to do in advance. I've got a couple clients selling their law firms right now. If you email me, I'll send you the checklist, and that is there, all set.
Okay, well, I knew that we had a ton of material to go through. When I saw it all, I was like, okay, we got to get going. So Nancy, thank you so much for sharing. It sounds like you have an extreme bountiful basket of knowledge to share, and I appreciate you taking the time to share it with all of us. We are planning to send the full slide deck, right? Okay,
right. Let me get it in PDF for you, though, before you send it.
Yes, I do have a PDF version, but I'm going to send all those slides over to everyone shortly. And yeah, just one more thank you for your time and energy and efforts today. Thank you all for joining us. And we hope to see you in a couple weeks.
Questions?
I didn't get any more questions, but I did get a thank you.
Oh, well, thank you. Oh, Scott's there. We have Scott Singer on. He joined
Yeah, he's been on for the show, so that was a bonus.
Oh, he's saying do not intermix business and personal.
Yeah.
Don't give IRS or the Department of Labor or Revenue to come after you.
This weekend is Halloween, and I believe it's daylight savings time. So just a quick reminder, everybody have a wonderful weekend. Stay friendly and happy, and stay safe.
Great, thank you.
You're welcome. Bye.
Jeff Hornstein answered the LLP question.
Yeah.
Good. All right.
Bye-bye.